Live on, going live on YouTube on DC 112904, Bank Midwest NA versus Richard A. Myers. Counsel, make your appearances.
Good morning, Your Honor. Keith Arzeda and Bradley Purcell on behalf of HCB Real Holdings, LLC.
Your Honor, Bill Wolf on behalf of the defendant Richard Myers. And can you see me?
Nope.
Okay, hold on. I got to figure it. Hey, Ainsley, how do I?
It's okay, Mr. Wolf. We can hear you, which is the important thing.
Okay, she's going to do the. Oh, okay, a camera thing. I'm still working through this. Okay.
Your Honor, Scott Seidel, I'm the receiver. Your Honor, I'm here.
Okay, great.
Thank you.
All right, let's go ahead and proceed. We've already heard initial argument about this, about the notice issue, but there's some evidentiary things that the plaintiff would like to put on, or the receiver would like to put on the record. So we decided to go on YouTube for this and put this on the record. Mr. Mitchell, was there anything else you wanted to put on the record?
Your Honor, do you mean Mr. Wolf or Mr. Arzeda?
I'm sorry, Mr. Arzeda.
Yeah. So just briefly, just for the record, Your Honor, I know you heard my argument before. I'm going to very short fashion summarize the prior argument that I've made. The receivership was entered on February 26, 2020. There has been the suggestion that Mr. Myers was entitled to service of the application of the receivership order. The Texas Supreme Court, the statute itself, the Texas Rules of Civil Practice and Remedies Code are clear. There's no notice required. It's a procedural device. The case there is Ex parte Johnson, 654 Southwest 2nd, 415. It's a Texas Supreme Court case. There's Fifth Court authority in the Goodman versus Compass Bank case. And I could make a very long string cite. I'm not going to do it, but the law is clear. Mr. Myers was not entitled to notice of the application for the turnover receiver. Did he get notice? Absolutely. How do we know that? Mr. Myers' counsel acknowledged receipt of a courtesy copy via email in February. A copy of the order was served on Mr. Myers' counsel on March 22nd, and an appeal by Mr. Myers' counsel was filed on March 27th. So why are we here? They've known about this receivership order, Your Honor, since at least, let's call it just the date of the appeal, March 27th. And since that date, Mr. Myers has done nothing to pay the receiver the judgment. And until we had a hearing on the 16th of June, he didn't even produce any documents. Excuse me, 15th of June. We are aware of a reservation of rights that was accompanying the documents produced to the receiver earlier this week. My client is entitled to see all of these documents. We have not looked at them because of the reservation of rights. So at the end of the day, we're going to ask the court to let us see these documents so we can determine whether or not they were complete. Whether or not the court has jurisdiction, court clearly has jurisdiction. It's not superseded by the appeal. Texas Supreme Court has found this in re Shestui, 154 Southwest 3rd, 114, Texas Supreme Court, 2004. The evidence I'm going to put on today, Your Honor, is I'm going to call two people to testify. First, I'm going to call the receiver, and I'm going to ask him what he got. And he's going to tell you he got some records. I'll let him explain what they were. And I'm going to ask him, did he receive any non-exempt assets? And the answer to that is no. Mr. Myers has not paid on this judgment since it was entered in 16. Hasn't paid a dime. He has non-exempt assets. He's not turned them over. He's in complete contempt of this court's order. And then I'm going to call Mr. Myers, and he's going to confirm that fact. I have nothing further in opening, Your Honor. I will call my first witness whenever the court pleases.
Let Mr. Wolf.
Of course, Your Honor.
Thank you, Your Honor. I'm surprised because Mr. Arzeda just talked about notice, but he didn't mention the fact that he actually has a brand new receivership amended order that he submitted for you to sign today. And I got notice of that they contend that the hearing can be this morning. I got notice of it at 4:05 yesterday afternoon. I received the motion Tuesday or Wednesday, just a couple days ago. But I don't know, in light of that, are we here on the order that they want you to sign or the order that you did sign that we didn't see from us? So
that's a good question. Which order are we here on?
The order you've already signed, Your Honor. Let me put this snake right on the table. We don't think this amended order is necessary at all. We think Mr. Wolf's argument is nonsense. However, if he takes the position that Mr. Myers could not perform under paragraph 14 of the order because he did not get service of that order in the 14 days from its entry, and the court finds that that's what that order meant, we don't think that's what the court meant, because if you look at paragraph 4 and other elements of the order, we don't think that's the same. If the court finds it necessary, we'll do it, and we'll start the receivership today. We think that's completely unnecessary, but we did it because of this argument raised by Mr. Wolf. It's nonsense, but we are fully willing to go forward on that. But for purposes of today, I think Mr. Myers is in contempt of this court's order entered in February, and that's what we're going forward on.
Okay, response.
Okay, I just thought it would be important to understand because they literally have a first amended, which of course would supersede and has not. And if in fact it's perfectly clear, I just go back to the application that we started this on, the motion for contempt, and we read this the last time. Further, the order requires Myers to provide within 14 days of the receipt of the order a sworn financial statement, list of non-exempt assets, and other financial records. That is a complete misconstruction of the clear language in your order. Your order says to do those things in paragraph 14 within 14 days of the entry of the order, and no one got the order within that 14 days or even within anywhere near there. So the fact is that the very application alters your language, because your language is, my argument is that it doesn't apply. So I want to make that clear, that we're here on an application for contempt that literally seeks something that's the order doesn't say, and now we have an order that's an amendment that changes it to make it exactly the way I understand the order should. I mean, it's just what it says. It's just the words that the order uses, and it's contempt. So we're not talking about going beyond the letter of either the application or the order. So let me go through a couple of the other things. I agree that there's no notice required for you to sign the new order. It can be done ex parte. In fact, the string side of cases, Goodman v. Compass, I'm the appellant, so I'm very comfortable that's what it says. I'm not going to sit here and tell you otherwise. You can pick it up, and it would be bad to see that Bill Wolf was the appellant's counsel and say that I'm making an argument that's contrary to what the court did. So I'm not here to I don't understand that, but it's very strange to talk about the notice but not tell you that what they're here doing is they've actually filed a motion to be heard with no notice to completely supersede what you did, because they know that the language doesn't say what they say it says. I understand they say, oh, it's what you intended or you thought. It's an order. It's contempt. It's an application where you have to be clear absolutely what you're saying. The law is clear, completely clear. Okay. The thing that I complained about was not that there was not notice. My complaint was the certificate of conference says I was opposed, and that's false because we didn't confer. And I don't think Supreme Court said in that case, in ex parte, whatever, that you can file a false certificate of conference. Then it says that it was mailed to me, and it wasn't mailed to me. And I don't think the Supreme Court said that you can say you served something on me by mail and you didn't. I think that's just called, like, the current political climate. We just do whatever we want. Okay, so the reservation of rights. First of all, he says that I sent the documents that we sent on Monday consistent with your last order, and we sent it Monday night subject to a reservation of rights. I sent him to the receiver because the order that you signed and the second order you signed said send it to the receiver. The receiver is not on their team, at least not supposed to be. He's an adjunct to you, and he's supposed to be indifferent. And the receiver then has some accountability. So when I don't get, when I have a certificate of conference that's false and I have a certificate of service that's completely fabricated, I'm not really crazy about sending stuff to the lawyers. So I appreciate the reservation of rights. It says reservation of rights, questions and comments, and it's very long. It talks about case law, talks about the fact that the receivership order deals with LLCs and partnerships, which are subject to their own exclusive charging order. So it's violative of that. It talks about Schultze, and I agree that Shevchenko or whatever that case is in the Texas Supreme Court might in fact change Schultze's position, but it's not clear.
Can you guys, for the sake of the court reporter, can you spell Schultze and Shevchenko?
I can spell Schultze. I think it's SCHULTZ. Does that sound right?
That's Schultz. You're saying Schultze?
It's an E at the end.
E at the end. Okay. And what's the other name?
It's a Texas Supreme Court case. I'm going to let Mr. Arzeda handle this, the subsequent one.
Okay.
Do you know how that, Mr. Arzeda? Do you know how
spelled SHESHTAWY, and the citation is 154 Southwest 3rd 114, Texas Supreme Court, 2004.
And Judge, I've read a law review article, I forget her name, at Baylor that writes on all this, and that case may, but it's not clear that does and takes away what Schultze says. And Schultze says, as I quoted in my reservation rights, this is inappropriate for me to tell them the case law. So I cite to the case and I highlight it in blue, apparently making that argument when I'm providing this stuff, because I think it's all wrong, is somehow wrong. I don't know. I mean, I've been doing this for 38 years, never heard anyone say that I can't point out cases. I also said in my reservation rights that Scott Seidel was calling my client and he's a lawyer. And I thought that was improper. Now, I don't know, maybe it's not okay for me to say that it's improper, but I don't call people that are represented. So it was that kind of thing. I don't know how. And so I didn't want to comply with this order that I think has got all these problems, and then have everyone turn around and say, "Oh, you waived it. You didn't pay any attention to all this. This is all kind of." So that's what I did, and I did this long reservation of rights letter at 6:42 p.m. And I explained all this. It's overbroad in paragraph 14, and the Schultze case, and it goes on at great length. Then, because you have a court order, we sent a series of emails. I sent to the receiver because that's what the order was. Of course, he's supposed to be indifferent. I sent a financial statement and a list of exempt assets. That's 14A and 14B. I sent that at 6:47. I'm sure Mr. Seidel will agree that he got those. Then I sent each time I sent these, I sent them subject to my arguments, because I don't know how anyone could say that providing arguments about things that I want to reserve that are legal positions are somehow inappropriate. Never heard that before. So I sent a bunch of bank statements, because that's one of the things in 14. And 14 doesn't apply because we've already talked about the fact that they want to change it and it's not what they said in their application. All I'm doing is complying because you have a court order and I don't take court orders lightly. So we send them JPM bank statements, Next bank statements, Regions bank statements. And then I sent a third email and I sent a whole bunch of other bank record. We tried to get them all the information that was part of paragraph 14, even though paragraph 14 by its terms applies to 14 days after February 26th and no one knew it existed. And I don't think due process suggests you're in contempt for something that no one knew the deadline existed or the requirement was there. That's why you would do a new order like they've asked you to sign today. Okay, so with that, just as a little summary and precursor, because you're hearing about how we're being so difficult, we've got, basically we provided corporate and partnership organizational documents. We provided tax returns, K-1s, income statements, balance sheets, and 215 bank statements. Now, this is on something that doesn't apply because it wasn't given to us within the 14 days to do, but we're just doing it because, again, because there's a court order and we're trying to be solicitous to the fact that I don't have many contempt hearings in my career. And then we gave dozens of copies of checks, his personal financial statement, a list of exempt assets. The financial statement, list of assets were sworn to as required by your earlier, what I would consider to be it's got its own set of its own problems with how it was obtained. You issued a receivership whereby there is, and the reason the appeal, and our brief is due a week from today, I have serious issues about whether or not you can be doing this and just serially changing this at every moment, and we'll take that up with the Court of Appeals. But we have a situation where we have given them 1,000 pages on something that isn't really required, in my estimation, at all, and we're trying to be compliant. I think it's almost 1,000 pages that were given, and yes, I did reserve all these legal positions. You know, I'm old-fashioned. I defend my client. I don't know how anyone would have a problem with that. Anyone. So that's it in a nutshell from our side, and then we can hear whatever evidence they want to deal with here. But if we're going to have a new order, it seems like
right. So let me hear from the other side.
Your Honor, I'm prepared to proceed with evidence at this point.
Okay. Go ahead and call your first witness.
I call Scott Seidel.
Mr. Seidel, please raise your right hand. Do you swear or affirm the testimony about to give shall be the truth, the whole truth, nothing but the truth?
I do, Your Honor.
You may proceed.
Mr. Seidel, can you introduce yourself to the court?
Yes, sir. My name's Scott Seidel. I'm an attorney, bankruptcy trustee. I've been practicing for 35 years or so.
Okay. Did you attend the last hearing in this matter on June 15th?
Yes, sir, I did.
You heard the judge order Mr. Myers to comply with the receiver order dated February of this year?
Yes, sir.
Okay. Let me cut to the chase. Has Mr. Meyer complied with all of his obligations under the receiver order?
I do not believe he's complied with all of his obligations under the receiver order.
Why not?
He did provide a lot of documents, as counsel indicated. He did not turn over non-exempt assets, for example, cash, etc.
What are the non-exempt assets that were not turned over?
In his financial statement, he describes about $39,000 at a couple of banks. I would expect to have received a check in those amounts. I don't have those funds. He has an ownership interest in various entities. I did not receive any stock transfer, any transfer of the interest in that non-exempt stock. The jewel appears to be, by looking at these financial statements, the debtor's alleged 39% interest in the S.R. Myers Family Limited Partnership, which he ascribes a value of $277,000 to. I did not receive any assignment of that interest. He does say in his affidavit that that interest is subject to a pledge to his lawyer, Mr. Wolf's law firm. However, it appears he still owns it and can transfer it. I didn't receive that. The latest order granting plaintiff's motion for contempt asks for a written statement to the receiver that describes and identifies all income. While these bank statements do indicate income, it doesn't indicate where some of this income comes from, $90,000 here and there. There are hundreds and hundreds of thousands of dollars of income, apparently in the line items from this entity again, S.R. Myers Family LP. But there are a lot of deposits that I don't know where that money came from. There's also a note receivable, according to the financial statement, for $7,500. And unless I miss it in the overwhelm, the length of documents here, I don't see that note anywhere. That's generally speaking the items that were not turned over.
All right, so I want to summarize this. You start with $39,000 in cash that was not turned over.
Correct.
A 39% interest in a limited partnership was not turned over, correct?
Correct.
And how much was that limited partnership valued on the statement?
On the statement, it's valued at $277,400. On that particular entity, I did not see in the documents any balance sheets, financial statements, et cetera, where I could ascribe a value or figure out the value. I didn't see anything with regard to the entity S.R. Myers Family LP, where there's been hundreds of thousands of dollars issued to the debtor, $400,000 issued in March of this year.
Explain that to the court. What happened in March of this year?
There was a deposit into the debtor, I'll call him the debtor, Mr. Myers' account of wire in, and it says on the wire from S.R. Myers Family of $468,000. That's after entry of the order here, obviously.
So, Mr. Seidel, if we were in court, I would have a whiteboard and I'd draw this out. Okay, so I want to make sure who did the money come from and who did it go to?
I can't testify as to where the money came from, but it says in the wire note on the bank statement, it says wire transfer S.R. Myers Family, $468,000 in March of 2020 after entry of the order here. And then there appears to be a withdrawal. It says IRS 460,000, but it's just the notation on the bank statement.
So to be clear, after this court's order was entered, the debtor, Mr. Myers, received $468,000 in cash.
Correct.
Did he turn that over to you?
No, sir.
Would he have been obligated under paragraph 4 of the receivership order to turn that over?
I believe
That's
so.
a legal conclusion.
Mr. Seidel, you're the receiver. Would you have expected him to turn that over?
I would have, sir.
Why?
Because it's described in the order to turn over non-exempt assets. That's clearly a non-exempt asset.
Okay. Has the note receivable you described been turned over to you?
As I said before, I did not see it anywhere. I've combed through the documents. I didn't see it. If counsel wants to point me to it, I'll sure look for it.
Great. In your review of the documents that you received, and again, I haven't reviewed these, did you identify large transfers other than the one you've described to the debtor?
Yes, there's hundreds and hundreds of thousands of dollars over, the last couple of years at least, to the debtor. Yes, sir.
Okay. Have you seen, in reviewing the records, donations made to charities since the court entered the receivership order?
I see a check on March 5th, 2020 to Save the Giraffes Now for $25,000. I don't know if the debtor's wife has an interest in that entity or has something to do with that or not.
Your Honor, at this point, I will pass the witness.
Ross?
Yes. Now, Mr. Seidel, you went to the Dentwood house on March 17th, did you not, to deliver these papers, correct?
I believe that's the date. I'll take your word for it. Yes, sir. I can go look, but that sounds right.
Okay. I mean, you don't dispute that that's within a day or two?
Correct.
Okay.
You're right. You're right. I'm looking now at my time records, March 17th. Yes, sir.
Yes. Okay. Can you tell us any time prior to that date that you know that the court's signed order was delivered, emailed, hand delivered, sent to me, sent to him ever before that date?
I noticed that you're the counsel of record in the case. I would have thought that it would have been ECF to you by the court when the entry of the order, you would have been watching this particular thing. I did not send the order prior to that date.
But you heard me testify at the last hearing that I had no notice whatsoever. Do you remember that?
I do.
Okay, so notwithstanding your speculation about what you thought would happen, my question is a real firm, fixed, objective question. Can you tell the court any evidence that this order was sent, delivered, provided to Mr. Myers or me as his counsel prior to March 17th of 2020?
Not by me, sir.
Okay. Are you aware if any of the counsel that you want to share these documents with did that?
I'm not aware.
Okay. And when you went out on the 17th, you didn't see Mr. Myers. You left it at the front porch or with the housekeeper or something like that, right?
Right. Had a nice conversation with the housekeeper, Mr. Myers. She said was in Mexico vacation.
Yeah. You went through that last time. I didn't ask you about the conversation. You said that the last time, and I'm not asking about that. I'm saying you didn't give it to Mr. Myers, right?
Right. She said he was not there. I gave it to her.
Okay. All right. So and do you still agree with me that the application for contempt, when it says that Myers is to provide within 14 days of the receipt of the order a sworn financial statement, list of exempt assets, and other financial records that would allow the receiver to perform his duties under the order, you agreed in the last hearing that that was false because it doesn't talk about receipt of the order, correct? There's nothing
Object to
in
the question.
order.
It misstates the prior testimony, but the witness can answer.
Well, the judge make, I guess, those calls.
I object to the question is argumentative, Your Honor.
Appreciate that.
Testimony was what it was.
Okay. You agree? Do you still agree that there's nothing about receipt of the order in the order, correct? In paragraph 14?
I believe we went through this exercise last time, and it says 14 days after entry of the order, according to the order entered.
Right. And have you seen the proposed amendment that changes that from 14 days from the entry of the order to 14 days from the date the new first amended order is signed?
I've glanced at it, yes.
Well, you were specifically, you didn't oppose it, right? You were asked about it by the lawyers. You said you were not opposed to that amendment.
I don't oppose it.
Okay. Do you think that amendment is a good idea?
I'm not sure.
Okay. Now, going to the actual order that you're interpreting about how it happened and all, can you look at paragraph 3 of the order that was signed on February 26th?
Paragraph 3, I'm with you, sir.
Okay, the second sentence starts out, the defendant and his respective officers, managers, trustees, escrow agents, facilitators, agents, servants, employees, attorneys, and all other persons in active concert or participation with them are hereby restrained and enjoined from directly and indirectly transferring, setting off, receiving, changing, selling, pledging, assigning, liquidating, or otherwise disposing of or withdrawing any receivership assets. Did I read that correct?
You did, sir.
And then it goes on to say, this freeze shall include, but is not limited to, non-exempt funds located in any bank accounts, brokerage accounts, or any other accounts or property of the defendant described herein. Did I read that correct?
You did.
So what you're proposing when you say there was cash in a bank account, which obviously was frozen, because that's why the money's in the bank account, because it had to be frozen. Your take is that when it says you freeze all bank accounts, except the ones that you now tell us have to be unfrozen and paid to you.
No, my read would be that the accounts are frozen. He can turn over the funds to me, to the receiver.
Okay, and you get that. And how, okay, all right. And do you remember my reservation of rights where I basically indicated to you that which of the two provisions would you like us to violate? The one that requires us to turn it over to you, or the one that says, the two sentences that say we can't turn over anything and it's all frozen, which is why it's frozen in that account? Do you remember me saying that?
I do.
Okay. And you think it's inappropriate for me to say that, right?
You can say whatever you want.
Well, no, you actually said that I made threats to you in an email, correct?
You said you threatened me with, I said you threatened me with the trespass stuff.
Yeah, I made it clear that trespassing at his wife's house that he doesn't own constitutes trespass. And you think it's improper for me to tell you that you're trespassing and put you on notice and reserve those rights.
Objection argumentative.
Saying, let's move on.
Okay. You said there was some kind of income disclosure in the June 15th order, correct?
Yes, I'm looking at it. Let me get the dates right. June 18th order talks about written statement to the receiver that describes and identifies all income.
I think it's the 15th, isn't it?
No, my eyes are not what they used to be, boss, but I'm looking at it. It could be 15th, could be 18th.
Well, remember we were here on the 15th and it was signed and discussed and proposed on the 15th?
Yeah, I don't know if the order was signed that actual day, but that sounds like the right day.
Okay. And can you point out for me where that language comes from the order that was signed? In other words, that's just a new thing added when we came back last Monday, right? That's not anything that's actually in the order. That's just a new add-on as we continue to just issue orders that say things that aren't actually been ordered before, right? That's a new order.
I don't know where that language is in the other order, sir.
Well, do you know if it's, have you studied that to see if that actually is in the February 26th order?
I don't see it in the February 26th order.
Well, you know it's not there, right? It's just an add-on.
No, I don't know it's not there. It's a 10-page order. I assume it's not there. Otherwise, would it be there again?
Okay. I'll pass the witness.
All right, I just have a couple of recross questions.
Okay.
Mr. Seidel, look at the first sentence of paragraph 3 of the receivership order. What does that say?
Until further order of this court, all non-exempt assets of or under the control of the defendant are frozen except as otherwise specified herein.
So Mr. Wolf didn't show you that language, did he?
No, he did not.
Right. And so then what is paragraph 4? I don't want you to read it, but would you agree with me that paragraph 4 directs that Mr. Myers turn over non-exempt assets to you as the receiver?
Yes, sir. It also, yes, sir, it does.
Okay. And that order would extend to the defendant's officers, managers, trustees, and attorneys, right?
Correct.
Okay. No further questions, Your Honor.
Nothing further.
Okay. All right, let's go ahead and what exactly do you, Mr. Arzeda, what exactly do you want me to do today?
What I want you to do today, Your Honor, is find Mr. Myers in contempt for failing to turn over non-exempt assets.
Okay.
Fine him $2,500 and tell him to do it immediately. And then I want to set a subsequent hearing for further testimony. And I would like to call him today as well.
You want to call him today? Okay. So you want to, so what exactly are you asking for? You're actually asking for contempt, or you got what in the, you're asking for $2,500?
I want a contempt order, Your Honor, that forces him to pay $2,500 for legal fees. And I want you to direct him today to turn over non-exempt assets that have been identified by the receiver in testimony today, immediately. And I want a subsequent hearing so that we can come back and prove whether or not he's done that.
Okay. Response?
Your Honor, we aren't here on your order. We're here, we're here, you know, the bottom line is that we just prove your order is effectively 14 days. And we are here on something that they're saying by their own terms, they want to change. Again, they want you to order turnover apparently of the accounts that are frozen. And I totally agree. And a contempt order has to be clear and unambiguous and complete notice of what it says, according to the Supreme Court in multiple cases. But what they're basically saying is they want you to pick and select your order and then essentially ignore what the original order said. And it was frozen. That was our take, that it was frozen. That's why there's $30-some thousand for 3 months that hasn't been used, because I said I think the frozen part isn't subject to within 14 days and all the other uncertainties and ambiguities. But now they're asking you literally to do a turnover of membership interest when that is exclusively a charging order. I don't know if you remember, but a year or so ago, we went round and around with charging orders and it never got done. And that's the exclusive method. So what they're asking you to do is violative of multiple things, including their application. Their application says you have to have full and complete knowledge of what you're being accused of. The application says that we weren't doing this within 14 days of receipt of the order. That's a fabrication. So I think the frozen means it hasn't gone anywhere. The reason that there's $30-some thousand in the bank account is, it was my take that part applied because there was no temporal aspect to it, and it wasn't charging order kinds of things. But this is completely infirm, And I don't know why, if we've frozen and we haven't changed any of those things, we can't actually follow Texas law. I know that's we've got this idea that procedure doesn't matter, and it seems like a lot of that kind of goes by the boards. But
Mr. Wolf, no one has said procedure doesn't matter. No one has said any of the things that you're accusing the court or the opposing counsel of doing. And so I don't know where you're getting that from. No one at the court has never said procedure doesn't matter. So
I'm not saying the court, but the other side is saying it. They clearly are saying it. They're saying that you have to do it within receipt of the order. That's false. It's false. So we've been charged with contempt with something that tells us that the order says something it doesn't say. That's all. And it's frozen.
Your Honor, I would just ask that the court look at paragraph 4 of the order. Paragraph 4 is not ambiguous. It's not unclear. There's no date restriction. It says upon notice, the defendant and his attorneys need to turn over non-exempt assets. Crystal clear. Paragraph 14 is a disclosure advice, disclosure method. It's a disclosure and discovery for the receiver to aid the receiver, but paragraph 4 is the turnover.
No, because can I respond, Your Honor?
Sure.
Paragraph 4 says promptly deliver, and paragraph 14 clearly defines what promptly means. You have to do it within 14 days. I mean, that's the way I read it. Is you promptly deliver means that you go, that exact phrase is in 14, saying you got to do it within 14 days. So we know what promptly means. It's within 14 days of the entry of the order. Again, it just wasn't done correctly.
I do feel a little uncomfortable doing contempt at this point, and I do think don't we need a charging order to on this to have them turn over the membership interests?
Your Honor, I don't think that's correct. I think the membership interests are subject to the receiver's ability to sell them. If we wanted to get the proceeds, we might need a charging order from that. But this is a non-exempt asset that gets sold by receivers all the time. That's
without a charging order.
A receivership order like this is acceptable in my opinion. Now, I'll be happy to brief it to the court. And I do not have law on this subject. I do want to point out, I do want to complete my evidentiary record today and call Mr. Myers before we're complete.
I mean, this hearing has already gone almost an hour at this point, and it was scheduled for 30 minutes. How long do you need Mr. Myers for?
Less than 5 minutes.
Your Honor, may I briefly respond to the charging order issue?
Sure.
The statute used to be ambiguous. The Texas legislature said that charging order is the exclusive method to reach LLCs and LPs. That's what it says. It says exclusive. So I don't know when he says he wants to brief it or he's not sure. I'm just going off the text. And again, I'm not saying you're doing anything. I'm saying that's not what the law is.
Okay. Is that your understanding of the law, Mr. Ozeda?
Your Honor, I confess I'm gonna have to look at this. I don't want to misspeak. I have had receivers sell membership interests like this before. That being said, I don't want to misspeak to the court. And that's one of those things where I want to be precise and I want to be right. And so I'm just not prepared to opine on that right now.
And we've frozen in accordance with the order. So we've done, I mean, it's not going anywhere. We're frozen.
Let's talk about schedule here. Do you guys want an opportunity to be heard again on this, or kind of what would be the next appropriate step here, I guess?
Your Honor, I want to have another hearing on contempt. I want to examine Mr. Myers. I want to have him testify what his exempt and non-exempt assets are. Mr. Myers is a sophisticated businessman, and he will be able to answer my questions.
Why don't you just do a deposition on this? Why do we need to do this?
They've asked for that on Wednesday.
Your Honor, honestly, I think the court needs to hear it, because Mr. Myers has not paid one dime on this judgment since it was entered in 16. He clearly has non-exempt assets that he has not turned over. That is crystal clear from today's testimony. Crystal clear. He has to pay this judgment if he has non-exempt assets. And he's got a couple of ways that he can purge this. He can pay the judgment, he can file bankruptcy. But to not provide information to the court, not provide testimony, and not turn over non-exempt assets that are clearly in existence from the very documents that he's proved that he's turned over is just not acceptable.
I mean, I understand you want me to hear it. I can also read it, and it would be quicker if we did it that way. So I would suggest you go ahead and just take a deposition. You said it's the deposition scheduled for Wednesday. Is that what you said, Mr. Wolf?
No, I just got a notice. I haven't even opened it, but there's a blitzkrieg of filings they did. They want to now access his house, and it's actually his wife's house. They're not going to trespass anymore. So I think we're making some progress on following the law here. There's a whole bunch of stuff, including a request for a deposition, I believe. I didn't really focus on it, but is that not correct, Mr. Arce? Isn't there a request for a deposition?
There is.
Okay, yes. Again, trying to get ready for this, I didn't focus on those things. Because
what is the deposition notice for?
Mr. Purcell, can you address that?
Yes, 1 second, please. I'll have to pull up the notice. We've noticed the deposition for July the 17th.
Mr. Meyer, Mr. Wolf, are you available that day?
let me check. Hold on.
I'm available that day. Yes, Your Honor.
Is that Mr. Myers? Okay.
And we're going to do it Zoom, right? Because I'm a diabetic.
Yes, it's going to be via Zoom.
Remote.
Okay.
It was noticed as a remote deposition, Your Honor.
Perfect. Okay. I didn't open it, so I didn't know. But yeah, I'm not doing things in person for 63 and diabetic is not a good combo. Hold on. Let me open the calendar here.
So, Your Honor, we filed a motion to amend the receivership order to address Mr. Wolf's 14-day argument, and we have submitted a fresh receivership order that says he needs to comply within 14 days of entry of the order. Since the deposition is going to be on the 17th, we'd just like to get that order entered today, and I'll serve it on Mr. Wolf today. And then the 14-day clock, and then we can put that argument to bed.
Okay. You said you submitted that order. Let me see if I have that.
I'm okay on the 17th.
Okay, so everybody's available on the 17th. Mr. Wolf, I would encourage you in the strongest of all possible terms that the court will look with great suspicion if this deposition is quashed now.
Well, I'm not going to, if Richard Myers is available and I'm a male, I don't need to quash it. I can't, I mean, unless I get come down with COVID-19 or something. I mean,
right. Unless there's a health issue.
I mean, other than something, you know, I'm not planning on that.
Okay.
Nor am I going to get myself infected to get out of a deposition.
No, especially with your health.
Yes, exactly.
Okay, this is here. Okay, so Sheriff, do you mind, I'm printing something out with my coordinator, with Rhonda. Can you go pick that up for me? Okay, so I'm going to go ahead and sign the amended order. You guys are going to go ahead and do a deposition. After the deposition, go ahead and reset this, and we'll continue this hearing after the deposition is taken.
Your Honor, may I address one thing?
Sure.
You're going to sign this order this morning. What type of service do you want me to make so that Mr. Myers and Mr. Wolf know that the 14-day clock under that order has started?
I thought it specifically said that it authorized email service. Isn't that what you prepared and submitted to the court?
Mr. Wolf, I'm asking you exactly how you want to be served, because whatever you say is what I'm going to do, and we're on the record.
I'd like you to serve him in the ordinary course. But
He has your, what email address do you want him to use, Mr. Wolf?
we send stuff. He knows it's the same one for 20 something. It's the same one. He knows it. He sends me stuff. I mean, they don't send me a lot of it, but they do send me emails.
All right. Mr. Purcell is going to send you the order via email today. Please reply that you received it.
I will do so.
Okay. All right, I'm about to sign it, assuming we can print this out. And all right, thank you so much, guys. Just get this rescheduled, the continuation of this hearing after the deposition occurs, okay?
Thank you, Your Honor.
Thanks, son.
Thank you, guys.
Thank you, Your Honor.
Thank you. You guys are excused. Janet versus Macy's, did you guys show up again?
Yes, Your Honor. David Brzee for Macy's is here, and I believe Feeney Thomas for the plaintiff is here as well. And I think I see Shannon Ramirez, counsel for KBS. I think she's also here by phone.
Is that right? Mr. Thomas, are you there?
Oh, Feeney, you're on mute.
Yes, that's correct, Your Honor.
So we had a continuance hearing. You weren't there this morning, so I wanted to chat with you. So I guess there's an issue about the defendants wanted to take your client's deposition live. Thank you, sir. And I wanted to make it clear that that is not required in this court. In fact, it's strongly discouraged given the state of this pandemic. And so I guess there's some other reasons to continue this trial, but Mr. Thomas, what is your stance on all this?
You know, we are behind just from COVID and getting some of the records to prove up the case. I'd also like to take the depositions of corporate reps. There are two defendants, KBS, Kellermeyer. They were added much later than Macy's. Macy's was originally added in the case. And so I'd like to take some witness depositions as well as the corporate rep depositions of these defendants. And just getting records and bills have been difficult, even from third parties, you know, getting calls back have been difficult. So because of all that, you know, as well as some inconveniences by opposing counsel, we've requested a continuance in the case.
Okay. Has there been any effort to try to get these depositions set up of the experts? Sorry, of the corporate reps?
No, not yet. We have not.
Okay.
We haven't talked about it. But the records and the bills have been, the plaintiff does have a lot of records, a lot of providers, and so it's been difficult getting all of it, and we've been trying, so.
Okay.
Your Honor, this is Shannon Ramirez. We kind of put everything on hold. I know Mr. Nett has some underlying autoimmune issues, so we put everything on hold when all of this started, hoping that things would open up, and then we just kind of got behind on scheduling her deposition. That's why we pushed it off to August. but we have been having the issue on getting the records, as I had told you before, and Mr. Thomas just said. So we really did kind of stop everything for a couple of months, but since we've started back trying to get everything together, we still haven't gotten those records that we need.
Okay. I just printed out an order sheet. Sorry. We'll go ahead and reset this to January of next year. Let's try to get this thing moving. And I just want to make it 100% clear that unless there's a radical change in the course of this pandemic, the one thing is everything needs to be conducted remotely. That includes depositions, mediations, getting these records, all that needs to happen. It isn't a basis to continue this, that you want to take depositions live, you want to attend these live. We don't know when this pandemic is going to be over. And so we've got to keep the wheels of justice moving forward. And so I really don't want to see you guys again here on that particular issue. I will continue this. Let's see. What week in January next year do you guys want to do this? We do this on a Tuesday.
At this point, my January is open, so I'm fine.
Randy, can you look up dates in January? Fifth, 12th, 19th, and 26th.
I would say the 19th or 26th if they're available, unless someone else has another week they'd rather do.
I agree. 19th or 26th would work.
Currently checking on the calendar.
Okay.
In Your Honor, we do have the plaintiff's deposition scheduled for August 21st. We've already told Mr. Thomas that even though it's scheduled for in-person right now, when we get to that point, if things haven't changed or they've gotten worse, or then we are going to do it via Zoom. We just pushed it off that far to see if there was a possibility of doing it in person, just because we haven't had a chance to see Miss Jeanette and kind of get a feel for her. But we're going to do the deposition August 21st, whether it's in person or Zoom, and we've already given him those representations.
So, Judge, I was going to file a motion to quash today on it because the opposing counsel is insisting on a live deposition unless things change, and I don't think things are going to change by August.
No, you need to just go ahead and change your notice at this point. So if you're not willing to do that, anyway.
So, no, I never said I wasn't willing to do that. I just said since it's 2 months away, why don't we just hold and wait and see what happens at the beginning of August? But I've already in emails and in correspondence indicated to him that we will do it via Zoom, but I was just holding until sometime in August just to see where we are, because we don't know what's going to change. But I've already made representations to him in emails, and he knows that I've said that let's just hold that date, and if we're not going to do it in person, I will be agreeable to do it via Zoom. So I've told him that.
Okay, how do you categorize the if everything's okay? I mean, are you talking about if it's a green status here in Dallas County? Is that, or what does that mean exactly in your emails?
Well, I have no idea, because I'm still unsure of where we're going. But if everything is opened up and if everything is given the all clear across the state and people are doing in-person depositions, I just didn't want to limit us either way, because I know we'll do the deposition on August the 21st, and it most likely will be via Zoom. But things have changed weekly, it seems, in the state of Texas, and so that was the only reason why I just didn't do it Zoom at that point. But I've told them, obviously, if things are the same, worse, no change, then we'll do it via Zoom. I just didn't realize that there was a need, since we were 8 weeks out from it, to do it via Zoom at that point.
But Judge, plaintiff is quarantined. She's got some underlying health issues. And so she's insisting that it be a virtual deposition and that it be noticed as such.
I'm just telling you, if you want to bring this before me on a motion to quash, I don't know how things are going down in Houston. I've heard they're just as bad as they are in Dallas.
Right.
Imagine every judge in Dallas and every judge in Houston is going to tell you the same thing. This needs to be remote, preferably Zoom or something like Zoom. But if you want to make if you want to try to fight that out here, you can, but I would highly recommend you not do that and just go ahead and amend your notice.
Yeah. Okay. There's no reason to file a motion to quash. I just was leaving everything open to see where we were in 8 weeks, but I'll go ahead and do it via Zoom. And then if something changes in August in Dallas County and it looks like people are doing it in person, then I may approach the court, but I'll change it to Zoom and we'll go from there.
That's a good idea. What I'm going to be doing is I don't know what they're doing in Houston, but we have statuses. I think we're at red status right now. Unless we go to a green status in Dallas County, I'm not going to order anything to be in person.
Okay. And if there's a Zoom, let me just throw this out to you. I will amend it to do it Zoom. I'll do that either today or next week. If we get to a week or two before and everything is in green status, and that means in-person depositions are taking place, do I need to approach you and ask you about that? Or if it's green status, does that mean that you are allowing in-person depositions? I haven't addressed this issue yet.
You would need to talk to the other side. Obviously, if I don't know what the comorbidities are for the plaintiff and what exactly the status is going to be. If you want to do it live, I would suggest you guys talk it out, and if you can't reach an agreement, then reach out to me. But I don't know the comorbidities of the plaintiff. If they were an 18-year-old with no comorbidities and it's a green status, I would imagine I'm going to allow it live. But if it's a 52-year-old person with diabetes and heart issues, then I probably wouldn't order it even with the green status. And so I just don't know the comorbidities. But I would suggest don't even bring this to the court unless it's a green status.
Of course. And then I guess the next question would be, if we get to January and we're not green status, then we approach you for a new trial setting at that point, if we're not green status, or if because of her underlying. I know that's a long time to get to it, but
I don't know.
I just don't know what we're doing here.
Yeah, I don't either. You're set in January, I guess. We're setting you in January, so we don't know. I mean, January, feasibly the soonest I could see us, unless there's a radical change or a vaccine or something like that, the earliest I could see jury trials realistically going forward in Dallas is probably November. So that's why I set you in January. And May. If it turns out we're not doing jury trials in January, then we're going to continue this. If you guys wanted to do Zoom, we could discuss Zoom. But there's some technical issues here in Dallas County about doing a Zoom jury trial. So, but let's cross that bridge when we get there. I'm not going to make that kind of blanket statement at this point. So,
okay. Well, I'll change it to Zoom, and then if anything changes and if it looks like that we may approach you, but again, I wasn't opposed to doing it via Zoom. I just wanted to wait and see kind of where everything was, since everything seems to change on a weekly status. So we'll get an amended notice out, and thank you for agreeing to the continuance, and we'll talk to you soon.
All right. Thank you so much.
One second.
Thank you.
Sorry, what?
Okay.
Did we actually decide on which day in January?
January 26th.
Okay.
They just signed the order, so you should be able to pull it offline by Monday.
Okay. Thank you, Your Honor.
Thank you. Bye-bye.
Thank you. Okay. Bye-bye.
Ralph Lubin's Time versus Richmond Trust. Are the parties here for that?
Your Honor, Catherine Compton here as the movant.
Michael Tobolowski on behalf of the plaintiffs, non-movants, Your Honor.
Okay. I imagine you're going to want a record on this. So Tony, let's go on the record on cause number 1915404. Counsel, make your appearance.
Your Honor, Catherine Compton on behalf of all the defendants in this case.
Michael Tobolowsky on behalf of the plaintiffs.
Let's proceed on the motion to enforce.
Thank you, Your Honor. And I know that you've been going over on your prior hearings, and I do anticipate this should not take more than 10 minutes. Just by way of, and I really mean that, by way of brief background, this we served document production on the plaintiffs November 12 of 2019. We had to file a motion to compel in February of 2020, and you heard that March 30 of 2020. I attached as Exhibit A to our motion to enforce your order, and on the very first item, it was an order requiring that they produce their engagement letter since they're seeking attorney's fees. So the plaintiffs produced their engagement letter, and if you look at Exhibit B, it is materially redacted to the point that it was really pointless to even receive it. It was so redacted. So you will see that in my Exhibit C, I have 5 different communications to plaintiffs' counsel saying, can you please just you're asking for attorney's fees, can you please just give us the unredacted engagement letter so we can see the terms of your engagement? And plaintiffs' counsel refused. So then we were forced to file what we have here today before you, a motion to enforce Your Honor's order. And that, of course, is set for today. And so yesterday at 3:34, we received the unredacted engagement letter. And Your Honor, I'm not one to quickly ask for costs and, beat the drum on that. But this is really our 4th conduct of this type. We came before you, you may recall, on our motion for protective order and to quash because plaintiffs were seeking or demanding that Mark Richmond, who's 75, be deposed in person, and you granted our motion to quash, and we did it by Zoom, but we had to go through the expenses of doing that. And then you may also recall that in January 27 of 2020, the plaintiffs right out of the box filed the anti-SLAPP motion. So we spent thousands of dollars briefing that, and we asked for attorney's fees because you denied it outright. And at that time, you said, if you see a pattern of this, then bring it back to me. But I know Your Honor isn't one to quickly, grant, attorney's fees or anything like that. So I just wanted to raise this issue with you, Your Honor. We do have the unredacted engagement letter, and we appreciate opposing counsel getting it to us. But we just would like for this conduct to stop, and we believe that we are asking for $2,500 in attorney's fees, but whatever Your Honor might feel is appropriate, we just bring this before you. This really goes to the heart of our counterclaim that relates to vexatious litigation under the Texas Business Organizations Code. That all of this is really not going to the merits of the case. It's really just obstreperous behavior. So that is my entire argument, and I would just like that you grant some fees to try to stop this behavior.
Yeah, Mr. Tobolowsky, why did, I'm looking at the redactions right now. Why did you redact that portion? I don't know what was there.
The first redaction, Your Honor, is a description of the retention. It goes into the issues that I discussed with my clients that were going to be pursuing in this case, the things that I was evaluating initially. And the second set of redactions is explaining kind of the same thing. There were payments that were made prior to the filing of this lawsuit, and one of the aspects of the negotiation between myself and my clients was to attempt to carve out what essentially they could have now without filing a lawsuit from whatever we get after we file a lawsuit. And the reason they were redacted, Your Honor, is because they're just entirely irrelevant to this case. And in the 2019 Texas support case of Ramos Ventures v. UT Southwestern, it was made very clear that fee agreements are not, they may be some evidence, but they are not conclusive evidence, and a contingency fee agreement especially is not sufficient for me to prove up attorney's fees. In order to prove up attorney's fees, I've got to put on and present evidence of the work that I've performed, my background and expertise, and the reasonable hourly rate of my work. My contingency agreement does not go towards our claim for these fees at all. That being said, I did produce it yesterday for the sole purpose of trying to save this time. And in response to the argument made by opposing counsel that essentially we are just in bad faith and running up fees, based off of the case that I just cited to the court and provided to opposing counsel yesterday, to me, it is very clear that this dogged pursuit of our engagement agreement in complete unredacted form is solely to harass me and my clients and to try to push us into some sort of resolution because of forcing us to disclose things that we don't believe we should have to disclose. In addition to that, opposing counsel has acted equally. I would say the parties have acted the same in discovery. There is not a pattern of abuse on the part of the plaintiffs. For example, the defendants forced the plaintiffs to go review 10 boxes of documents at the defendant's office and pay for the entire production, only to then get a copy of that production themselves. And so I think that there's been some statements that have been misrepresented to the court about the conduct on the plaintiff's side. And I don't think that attorney's fees are appropriate for that reason. And I think the whole issue is essentially moot at this point.
Ms. Compton, I kind of understand your concern here. I mean, obviously, this has been frustrating to get this. Is that an accurate statement of what was left out, or is that an accurate description of the redaction?
If you look at the paragraph that's redacted, and he did give it to us yesterday, but I was on the road. It's paragraphs that it'll say he gets 50% of, and then all the rest is redacted. And so it just explains the terms of the fee agreement. And so, like, without that language, you just really don't have any idea of what the fee arrangement is. Importantly, it's what Your Honor ordered, and whether opposing counsel believes that it's relevant or irrelevant, it's what you ordered. And so to wholesale redact it where we don't have any idea what it says just went against what the court ordered. And so
did the order say produce the entire fee agreement, or
it just said it's the very first item, and it just said produce the engagement letter granted. I don't know if you can see it, but I have it here, and you just put a check, just engagement letter. And
that's share screen the old school way, Ms. Compton.
Yes, that's because I'm old, Your Honor, but
no, yeah. I'm not saying that.
Yes, but nonetheless, we have it, and we do appreciate getting it, and all we want to do is try to move the case to trial and not have to come to Your Honor or wait, and it was gamesmanship in the last minute to not have a hearing. We would like to try to avoid that and move forward, with the case in chief and get to trial.
I'm going to award $1,000 in attorney's fees to be payable at the time of judgment.
Thank you, Your Honor.
So if you could give me an amended order on this, and I just mostly wanted just to encourage you guys to both work together on this. And again, I'm not going to force it to be paid now, to be at the time of judgment. So if you could email that that order to Mr. Tobolowski and then to my court coordinator, I'd appreciate that.
Will do. Thank you, Your Honor.
All right, guys, you be safe out there, okay?
Thank you. Bye-bye.
So is anyone here on the Williams v. Torres case?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Oh.
Oh, that sounds like my house.
Yeah, me too. I understand that.
They've been quiet for an hour.
And as soon as you start your hearing, hey, trust me, I get it. So you guys, we have a scheduling conference. When do y'all want to set this for trial?
Your Honor, we've agreed this morning to set for trial on June 14th, 2021.
Rhonda, are you on the call? I can't tell if she's on the call. It looks like she is, so she got it. Okay, June 14th, and who do you want to use as your, is Mr. Rogers your opposing counsel?
Yes, Your Honor. We spoke this morning and have agreed
Well,
on.
he just
There
fell
he
off
is.
the call. There. Let me let him get back on.
Judge,
So-
I'm back. I apologize.
So June 14th, is that a Tuesday?
It is a Monday, I believe. Should it be a Tuesday?
Should be a Tuesday. Yeah, we try cases on Tuesday.
Okay, then June 15th. If that's all right with you.
June 15th is fine with me. Hopefully we'll be doing jury trials by then.
Yeah,
Have you guys agreed to a mediator?
Yes, Your Honor. We've agreed on Gary Berman.
That's correct, Your Honor.
We'll go ahead and do a mediation order with Gary Berman. We'll set this case for trial. And if you want a full scheduling order, you can do that. Did you submit a full scheduling order or not?
Not yet, Your Honor, but we can.
And Judge, we agreed to the term. Oh, sorry. Excuse me, Your Honor.
Go ahead, Mr. Rogers.
I was just saying that we're agreeing to the terms of the uniform scheduling order from the court. We've gone over the terms with regard to the deadlines, and we're in agreement there.
Yeah, so just get me a version of that, however you want to put with the style on it and everything. We're very flexible about the what exactly is in there. The only thing I prefer is if dispositive motions are heard at least 30 days before trial. That's my main concern. But other than that, I'm pretty flexible. So yeah, if you guys want to submit that to me, that's fine. But we'll go ahead and get this set on June 15th. And then get you a mediation order. And I'm sorry you had to wait around, and you guys be safe out there, okay?
All right. Thank you, Your Honor.
Thank you.
Thank you, Judge.
All right, bye-bye.
Bye.
We have anyone here on case 17 GmbH versus Maple Heights? Anyone here on that? Mr. Martin and Mr. Hess, are you here for the TRO?
Yes, Your Honor. Brant Martin.
All right,
And
let me do that.
Mr. Mitchell will be, I apologize, Your Honor. Mr. Mitchell represented my firm yesterday. He'll be on the call as well, but I wanted to make sure I wasn't late.
Oh, it's not 10:45 yet, is it? Okay. And then,
Yes, Your Honor.
so nobody is here. Mr. Hess, are you here for is he here for the TRO as well?
Yes, Your Honor. Mr. Hess is the general counsel of my client, of the plaintiffs.
Mr. Elkins is here as well?
Yes, Your Honor. Yes, Your Honor.
So no one is here for the Maple Heights case. All right, so let me do this. I'm going to go ahead and mute you guys. I'm going to just take a quick break. You guys are welcome to take a quick 5-minute break, and we'll start up in 5 minutes.
Thank you, Your Honor.
Oh, there's Mr. Mitchell. All right, we're going to take a quick break. There's a number of new people here on the call. Is there anyone here that's not here for the TRO? Any attorneys or parties are not here for the TRO? Okay. Tony, you don't need to be here. I don't think she is here. This is a TRO, so we don't do this on the record. Tony, you're excused. Tony, we'll see you next Monday, okay? Bye, Tony. I don't know where she is. Bye, Tony.
All right. Have a good weekend.
Till Monday.
All right.
Okay. All right, let's get started. This is currently on Zoom. Do you guys want me to take this off of Zoom, or is there confidential stuff we're going to be discussing?
No, Your Honor, we don't anticipate any confidential information that would require sealing.
Or just, yeah, okay. All right. So we started this hearing the other day. There's not two TROs set for today, is there? There's just one.
Not that we're aware of, Your Honor.
Okay. It's on the docket twice. I just want to make sure. And have you guys had a chance to chat about defense counsel? I knew had some issues about the case out in California. Have you guys had a chance to figure out, is there going to be any type of anti-suit injunction or any attempt, anything like that?
We have not spoken to the counsel for defense about that specifically. And
no, I was asking defense counsel.
Oh, no, sir, Your Honor, we have not. No, sir.
You haven't talked to the defense counsel in California?
All I've gotten from the defense counsel in California is the petition that they filed out there, and there was nothing involving antitrust.
No, anti-suit injunction.
Or excuse me, anti-suit injunction.
Okay.
Yeah, no discussion. No, as far as I know, there is no plan to do anything like that out in California, of which I'm aware.
Okay, let's get started. You don't need to go over anything you did before.
Sure.
So let's just go forward for anything else you wanted to add from the other day.
Your Honor, Ethan Mitchell on behalf of the plaintiffs, and as you recognize, there are some new people on the call. I would like to introduce Mr. Martin, who is joining us, who's the lead counsel on the file. Unfortunately, he had a conflicting hearing yesterday, but he is going to be here today specifically for the California issues, which he is a little more knowledgeable about than I am. So to the extent that you have any questions about what's going on out in California, I can pass the mic over to him. But I think there were a few things that came up right at the end of the hearing yesterday that I did want to address. The reason why we're here in your court is because this is a Texas contract with a Texas governing law clause. My client is based in Texas. Its headquarters is in Texas. Though there are some California issues, and as we said yesterday, we will be vigorously defending that lawsuit in California. What we're asking for here today, as I said, is just to prevent them from breaching the Texas provisions of this Texas contract. And I've been trying to think about this for the entire day, and the only reason I can think of that they would challenge us on this is because I'm right. We're saying that they are interfering with our clients, and that shouldn't be a hard thing for them to agree to not do. We are merely here asking for a judicial order that we can enforce to prevent that kind of action. I'm glad to address any other questions you might have, but from our perspectives, they only filed that California lawsuit to circumvent the very clear venue provisions in the Texas contract.
So let me ask you this. I'm looking at a couple of things here in the file. I want to make sure I'm not missing anything. Did you guys actually submit a proposed order for this?
No, Your Honor, I don't think we have submitted a proposed order yet. Mr. Elkins can confirm that. We do have one prepared, and we can email it to you as soon as you'd like, along with an order on the motion for expedited discovery that is included here.
Your Honor, this is Brant Martin. I have the draft order in front of me. And what we're asking the court to do is in line with the limited amount of relief that we're asking for in the petition. which is to prevent to order that the departing employees are restrained and enjoined against directly or indirectly interfering in any manner with any of New Western's customer, investor, or prospective customer or investor relationships. That's the meat and the substance of the restraining order that we've asked for, because that foots with the evidence that we've submitted before the court and the contractual provisions that we've petitioned the court under.
Go ahead and email that to opposing counsel and to my court coordinator. Her email address is rhonda.pinson@dallascounty.org.
Yes, sir.
So go ahead and email that right now. And then, so real quick, a response to that, Mr. Holla?
Just very briefly there, Your Honor, we have a witness here that I want to offer up for a brief testimony. Maybe
we don't allow witnesses and TROs, so that you're not going to be able to. You can submit an affidavit. Do you have an affidavit?
No, Your Honor, didn't have time to prepare an affidavit for it, but I can just tell you in essence what he's prepared to testify is that they are trying to freeze them out of the entire market in all of California. It's one thing to say they don't even have any definition of what a customer is, or what a prospective customer is, or what an investor is, or what a prospective investor in. Just anyone they feel like saying is a customer. Hey, that's who
Mr. Martin, that's a good point. Do you have a list? Usually on these types of things, it would be current customers, and there would be a list of current customers. Have you guys talked about that?
Your Honor, here's the issue, is that after the departing employees submitted their notice of resignation to be effective 2 weeks from that date, and that date's going to run on Tuesday, we accepted that resignation to run on the 14-day notice. At that point is when our investigation began, and we are still uncovering, but we have uncovered, and as is submitted in our affidavit, which is required by the rules, we have submitted that they have downloaded thousands of files, including vendors, customers, and investors, which are the lifeblood of this business. Now, we can attempt in the days that come to identify each and every one of them, but the amount of data that they have downloaded into their personal accounts, in which they are now claiming does not belong to the company, even though we paid for it and they did it on our computers, I'm not even sure it can be quantified now. And again, to Mr. Mitchell's point earlier, all we're asking is that they comply with the contracts they've already signed, which is they cannot interfere with the existing customers or investors or the prospective customers and investors. Those lists, that data, and it's terabytes of data, is ours. And they are going to use it.
How many customers does your client have?
Thousands, Your Honor. This
Thousands.
is a big business.
I don't know anything about the business, so.
Okay, Your Honor, if I may, and I don't want to cover anything that was covered yesterday, and I apologize for not being available, but the best way I can always describe this, even though it refers to a competitor, you've seen the billboards that say "We buy ugly houses."
Yes.
That's a competitor of ours, right? And so it's really kind of it's a wholesaling business. It's a matchmaking business between people that are selling these houses and the people that are investing in these houses, either to flip them or to rent them as an income property.
So Mr. Martin, the issue comes up, and I've dealt with this many, many times before, and it's just on it really protects you guys as much as it protects the other side, is if we don't have any type of list or any type of definition on who these people are that they can't do business with, then how do I possibly enforce that in contempt?
Well, the issue here, Your Honor, is that I don't have access to everything they've stolen because they won't provide us that access. We tried to recover it. They won't allow us to recover it. And so we're still digging out what they have or have not stolen. And I think the way around this, Your Honor, because I understand the logistical aspect of it. I think the way around this is, look, if in the future you enter the injunction, right, and says you can't do this with their lists, with their data. And if in the future we think that they have, then I come to the court on a motion for contempt. Then it's my burden to show that was one of ours. At that point, they're going to have some type of good faith defense, or they're going to say that wasn't.
How is that not going to be impermissibly vague?
the impermissible vague is because we are limiting it to I just lost it. Hold on one second, Your Honor. I apologize. It's not impermissibly vague, Your Honor, because if it comes from our data and we can show that it came from our data, which they took, then there's nothing vague about it. They know where they're getting these leads from. They know where they're getting these investors from. They know where they're getting this inventory from.
So how is, I haven't seen the order, so how is it defined in the order exactly?
I'm pulling it back up now, Your Honor.
Your Honor, I sent that to Ms. Pinson, but would you like to have a copy directly sent to you?
No, no, that's okay. Can you grab,
Your Honor,
I'm also happy to share my screen if you like, Your Honor.
That'd be great. Why don't you share?
Yeah, that'll probably help.
Okay.
I need to give you permission. There you go.
May I briefly respond, Your Honor?
Sure.
Okay, for example, basically what they want you to do is sign some big blanket order with any possible customer in the entire state of California, just in case it might be included in their customer list. That's one thing. Also, what they haven't informed you of is that a majority of these customers have signed a letter of non-representation. They are not exclusive customers and clients of New Western. So that would presumably, they're in their database. So that would actually be covered. That would be express violation of that agreement. So they're actually asking you to sign a blanket order for anything they might want to throw in there just in case they can prove it. And oh yeah, Judge, by the way, some of these things are going to clearly conflict with agreements that are already in place. So, and additionally, just it's a minor thing, I understand, but to me, it's a little bit of a distinction. It's not an affidavit. They've got a verification of facts in section 5 and 7 of the petition. And they do have the verification, but it's not a full-fledged affidavit where Mr. Dreyer laid out everything and said, which again, I understand it's a small thing, but I still think it's relevant.
Your Honor, may I respond?
Sure, but where is this? Is this it? Okay, is that where you were asking me to look, or you're moving it so I can't see?
I'm sorry, Your Honor.
Is it any of New Western's customer, investor, or professor? That is just way too broad. Customer, investor, or prospective customer or investor in violation of the. There needs to be some kind of definition on this, more specific than that.
And we're willing to work with them on that, Your Honor.
Your Honor, we can probably work with them to come up with a list of disclosed investors and customers. But I think that I'm going to want some type of a representation that we're going to be able to know exactly what it is that they've taken. There are leads. Many of these individuals that are in California, including Mr. Bake, who's on this hearing, they were the general managers of the California offices. They had direct access. They may have even had direct access to certain information that they took from us that we're not even aware what it is. Right now, and I'm not talking about Mr. Holla, but rather California Council has indicated to us that they're going to black box this and not give us access to anything, and that it doesn't matter, that was all our personal stuff. And it's our contention, and we have verified this, it's our contention that is our stuff that they've taken. So we're going to need some level of cooperation to determine the amount of the materials that they've taken. As it is, even without that, we can give you a disclosed list of the investors and customers. If the court wants us to do that, I'll work with the court however you want us to. But right now, the way this is positioned, we have a valid contract. We have an enforceable contract.
That's not the issue. The issue to me is just I get what's going on. I've dealt with this issue many times before. If the California is not filing any type of, if there's not going to be a situation, at least at this point, where California is going to try to stop me from going forward, then I'm willing to sign this order. I just want it to be specific enough that if they violate it, that I can enforce it. And this one, I don't feel that I can. So
I understand, Your Honor.
So that's my concern is
May I suggest a workaround?
What's that?
Perhaps if Mr. Holla and my firm can conference over the next day or so, I believe that we can probably try to work something out by Monday on a disclosed list. And if we, at that point on Monday, have not been able to reach an agreement on a disclosed list, both sides can appear before Your Honor, obviously at your convenience, to dictate, what the sides' respective positions are. Ideally, on Monday, we would be able to submit a list to say, Judge, these are the ones we want you to enjoin them from, and that both sides can agree. But if not, that'll give us the weekend to try to get a specified list that you would be comfortable with.
That sounds like a good plan. Did you guys send me a proposed discovery order?
I'm doing so right now, Your Honor.
Okay.
And it is up on my screen as well. We can work with opposing counsel on the numbers of requests and on the
now let's get this. I want to get this ruled on now. So what, do you have any problems with their scope?
Me, Your Honor?
Yeah.
Well, one, I did, and I might have missed it, but I did not actually see that in their prayer. So I would argue that they're not really entitled to it. Expedited discovery, as you know, is an extraordinary remedy. There's got to be exceptional circumstances. There's got to be good cause. It's got to be based on more than mere conjecture.
Mr. Hall, I've been doing this for 14 years, and in every situation where this has come up, I've ordered expedited discovery, and I'm going to order it here. So is there an issue with the scope?
You get to say this. That's totally your discretion. Understand.
So what is the scope? That's the question I have. Is
I think in that has been my concern since yesterday, and exactly what I've said today is, every single player, every single entity, every single anything is out in California. Now, they've got some headquarters here, but everybody that's involved with New Western, that is involved with the defendants, everything is all out in California. So there's a case going on there. So if they have captured, we've got the old axiom in Texas, to get equity, you've got to do equity. Well, they've basically been holding these guys as economic prisoners. So
Mr. Holla, they're asking for 10 requests for production and 3 depositions within the next 7 days. That's pretty ambitious.
Yeah.
I don't see the 10 requests for production being an issue, as long as it's both sides get the opportunity to do that.
If it's reasonable, if it's like anything that you've ever produced your entire time with New Western, I mean, that's a little bit much. But I'm assuming the objections are still permissible, like normally.
Yes, of course.
Okay.
And then 3 depositions in 7 days. Everyone's in California. How do you guys propose to do this that quickly?
Your Honor, I think everybody's doing depositions remotely now, and however much I dislike that process because it's not as effective, we understand that we are the ones asking for the extraordinary remedy. Therefore, the burden is on me to move heaven and earth to make sure that these happen. We limited it to the 3 depositions because we sued these 3 people, and we think that that's a fair compromise. I didn't come out of the gate asking for 10. We do anticipate, obviously, that these depositions will solely be on the issues that might be necessary for the.
So you have to understand, I can only see what's on the screen, and it says, I want to make sure I understand what you're asking for. Take 3 depositions in this matter upon 7 days' notice. Which 3 depositions?
Right now, Your Honor, we would anticipate taking the 3 depositions of the 3 individual defendants in this action, Mr. Miller, Mr. Bake, and Mr. Kahn.
Mr. Mitchell, if you could make that clear, can you amend this, what you're showing me?
Is that going to be sufficient?
I would say individual defendants, but I think I guess it's just individual defendants, so that's not a big deal. Okay. What did we say?
I think the 7 days notice, Your Honor, if I may, that's going to give both of the parties some wiggle room to try to move things around and make it more convenient for everybody. I see Mr. Bates on this call. You know, it is not my mission in life, unlike what Mr. Holla testified to ruin anybody. But, you know, I do want to avail myself of what's available under the rules. Now, if we can work something out where we push out a hearing date, we push out the depositions. I understand everybody is extremely compromised in their schedules right now. So I'll represent to the court. We'll work with them. I think that's why we put the 7 days notice. I don't think it was 3 depositions within 7
And
days.
Mr. Hall, I don't know if you've been in my court before. I've, again, dealt with these types of issues many times before. And 90% of the times in cases like this, you're probably going to need to agree to extend the injunction hearing, because to get all the discovery done, you're going to need that time. But that's something you can decide with the other side, and we can discuss.
It's been a while it's been a number of years since I've been in your court. What I would ask, if we could make it a little bit more clear, I don't want to get, and I don't know Mr. Martin, I just know that what they've done as far as economically make the clients prisoners. I don't want to be trapped into doing 3 depositions in 1 day. So, I mean.
Okay, that's fair.
Right now, and right now, can we also agree that they're going to be after because right now they're technically still employees. They've cut them off from everything, but they haven't fired them to keep the 2-week notice. So I don't want them to get in trouble for not acting.
When is their last day?
I believe
their last
day from now.
I believe it's June 30th, Your Honor.
Well, this requires 7 days notice, right?
Yes.
So
and I'll represent to the court, and I'll represent to Mr. Holla. I'm not going to take 3 depositions in 1 day.
Okay.
I'll put that in the order too. And Mr. Holla, is there any discovery you need before the?
I tell you what, I will represent to the court I am okay with their getting 10 requests for reduction. We'll limit it to no more than 10 deductions. They're getting 3 depositions, none on the same day with 7 days notice. We'll simply ask for the same.
Okay.
Your Honor, do they, I would be happy to present a 30B6 representative. I do not want this to be a fishing expedition on 3 depositions amongst the corporation when the company is the plaintiff. For instance, and let me just be clear so that the court understands where I'm coming from. I understand goose and gander, and I'm not trying to get around that. But for instance, if the corporate representative for all 3 of the entity plaintiffs in this case would be the same person, then I don't think 3 depositions will be necessary.
I can represent to the court, just like Mr. Martin did, that I'm not going to be repetitive and I'm not going to want to depose 3 different people on the same topic. But I've also had this case for 1 day, Your Honor. There's no way I could possibly have had enough time to get into what I would need to depose and who I wouldn't need to depose. And I think Mr. Martin, not saying there's any ill intent at all, but I think he's trying to unfairly tie my hands when he's asking for something. I'm simply asking for exactly what he's asking for. In my opinion, that is reasonable in light of the fact that I barely have touched the surface of the facts of this case and what's going on in this case.
I tend to agree with Mr. Hall on this, that they should be allowed to conduct discovery. I don't know, I mean,
understood,
who they want to depose, and I don't think I should tie their hands until we know. So I'm just going to put defendants will be allowed up to 3 depositions with 7 days notice.
Okay, Your Honor, just so that I'm never accused of laying behind the log, I do anticipate that California counsel may attempt some apex depositions that I might have some objections to, but we will certainly bring that up with the court, and I understand the court's ruling.
Yeah, I can bring that up. That's fine.
Thank you, Your Honor.
All right, I've signed the order on the granting of the emergency discovery. Try to get me a proposed order, agreed order, preferably on the TRO, or at least agreed as the form order on the TRO by Monday. And if you need to have a new hearing on this, on Monday. Do you want to just schedule that for Monday, or?
I think that may be
I will be out of town for business. Out in Taylor County, I have I got a client out there that I've got to go take care of some stuff, and I won't be available till Wednesday afternoon. I'll be Monday, Tuesday, and then back on Wednesday afternoon. So we could schedule it for Wednesday afternoon if everybody was good with that.
Wednesday afternoon? I'm sorry, say that you want to have the hearing, follow-up hearing on Wednesday afternoon?
I'm throwing it out there because somebody said, do we want to, I don't know if we even need a hearing yet, but if we want to have a date just in case, I'm okay with that, but I won't be available for a full-fledged hearing until Wednesday afternoon.
You know, the issue I'm having with that, Your Honor, is that as we discussed previously in this hearing, the defendant's employment ends on Tuesday. I don't know if there's going to be any type of
this
a
hearing
legal
needs to
threading.
take place, Mr. Hollow, this needs to take place. You can do it remotely, but it needs to take place on Monday. So what time can you do on Monday? Mr. Mitchell, I've already signed this order, so you don't need to edit it.
It's a compulsion, Your Honor.
As I guess as early as we can do it on Monday, because then
So
I can just leave after that. So yeah.
Not 9 o'clock.
Okay. I mean, if you do earlier, that'd be better. But okay, no, whatever you, as early as you can, Your Honor.
9 o'clock.
Okay.
Okay. Anything else, guys?
Not from the plaintiffs, Your Honor. We appreciate your time.
All right, no problem. You guys be safe out there, okay?
Yes, sir.
You will, Your Honor. Thank you. Have a good weekend.
You too.
Thanks, Judge.